you, the audience. Thank you, the moderator today. I'm Mei-Hsin from Taiwan. I formed my association 20 years ago. I wrote 2 books about Thailand monetization published by Cambridge Scholar Publishing. Like many of you, I provide service to AIPPI, INTA, LSI, and adjunct teaching in many universities in China and India, include National Law University, Jaipur, and Delhi. I also, like many of you, have been visiting scholars in CFC, MPI, TP, Russian Academy of Science. Before I became a full-time professor, I worked for AstraZeneca, Merck and Takeda in marketing, regulatory, clinical, and research development departments. And I also have been a consultant of Korean government IP fund intellectual discovery. They helped me to build up a skill today to moderate the section. Today, my esteemed colleagues, they will demonstrate the real case study how to develop protected IP measure and conduct due diligence for IPO, building up IP portfolio assessment process and perform IP evaluation for merger and acquisition. Nevertheless, my esteemed colleagues will also elaborate how to cultivate innovation strategic partnership and leverage IP strategy into business plan. So before handing the floor to my esteemed colleagues, allow me to address the importance why we are here today, because just the first week of January, Roche already signed 3 deals, 2 deals, 2 billion deals with MoMA for knowledge space to detect the new drug after the cancer cell growth and survival, and another 1 billion deal with China-based Nitin Therapeutics, and also another 1 billion with Remix Therapeutics to create the general small molecular therapeutics. Not only Roche have rushed in the merger acquisition, Bristol Myers Squibb also struck a 4.1 billion deal with Base Bio for cancer therapies. AstraZeneca Inc. 1.2 billion for China-based cell therapeutic companies. But not only pharmaceutical company, they are also eager in merger acquisition. Also, Taiwan company AUO, they have acquired Bayer Control company in Germany for 600 million euro last year. VT Electronics, also from Taiwan, acquired Future Electronics Canada for 3.8 billion US, also last year. For company who can have the competence, ability to perform merger acquisition, they have very powerful competence, not only business-wise, but also IP as the core. So today I would like to turn on the floor to our speaker.
Our next speaker is the Nitin Kaushik. Mr. Nitin Kaushik is a partner in the New York office of Dentons Link Legal, formerly Link Legal US PLC. Nitin is a multi-jurisdictional lawyer, having been admitted to the New York Bar, Canadian jurisdiction, and India. Nitin is also a registered U.S. patent attorney, as well as the registered patent agent with the Indian Patent Office. He brings over 23 years of various experience in intellectual property, commercial litigation, corporate advisory, and business immigration. Nitin holds dual Master of Legal degree from University of Warwick, UK, and University of New Hampshire, US, where he was also a visiting scholar and specialized in intellectual property. Mr. Kaushik, the floor is yours.
Professor Wang, really appreciate. I didn't even know that I did all these things until you read them to me. But anyways, thank you, Dr. Wang, for that beautiful presentation. I may not have a fancy slide as yours, but I'll try to keep it as informative as possible. And so today's topic is right IP strategy can maximize value, IPO, M&A, and enterprise. So I'll divide it into 2 pieces, 2 parts, and I'll make it very quick because I know I have other speakers after me. So what is the role of IP in shaping the M&A landscape? It's very important, it's a keystone for sustainable growth and keystone for competitive advantage as well. Because whenever you are shaping your M&A strategies, IP is something which is very, very, very important for the companies to take note of. Why I say this, I'll give you some figures. An M&A report was published in 2021 by Refinitiv. It's an independent company. And according to them, that global M&A deals surged to an unprecedented $5.9 trillion in 21. And this was an astounding about, let's say, 64% yearly increase from previous years. And out of this, more than $1 trillion M&A deals were only from the IP companies, like IP-based acquisitions by the company. So this is, in fact, according to a statistics issued by the USPTO, in 2021, the sectors of IP generated a $6.6 trillion in revenue, which is contributing 38.2% of United States GDP. And in fact, the same figure for European Union was more than 86% of their GDP, more than, like, I think, $10 trillion in EU. So these are kind of a very, broad figures, which can, give you some idea of how important IP can be in any M&A deals. Now the next question, that was the first slide, the quick figures part. The most important part for what we are discussing over here today is how to maximize, what strategy should you be looking for when you are shaping up your IP strategy. Well, like that will bring you more revenues to the companies. Now, if you think about it, when considering M&A, the buyers and sellers, they both have different approaches towards looking at the deal. The buyer's approach especially I'm talking only about IP, not about the corporate side. For buyers, the most important part is the validity of the IP of the seller. They have to check whether the patents or trademarks or copyright are in force, all the fee has been paid, and there is no pending litigation against them. For what is important for the sellers is that they have to document their IP assets. They have to make sure that all the IP assets of the company are in force, are sustainable for the growth of the company, and in fact at the potential acquisition or merger as well. Now, what are the key components of an IP strategy looking from the perspective of the IPOs, M&A, or even the enterprise? So the first one is identifying the intellectual property assets. So as Dr. Volk clearly pointed out in his presentation, that it is important for you to talk to your inventors, talk to your R&D department, what assets can identify. Like, for example, companies like IBM or Huawei files more than 3,000 or maybe about 4,000 patents worldwide in a year. So they are identifying those assets, their IP assets, which can bring them money or which can be good for the growth of the company. Second strategy that the company should put in into their system is setting up clear goals and objectives. Like when you are establishing brand recognition or you want to generate revenue through your licensing agreements, so you have to set those clear goals and objectives that what company is looking for from their IP, what is their goal, or what do they want to achieve if they are investing heavily into developing and identifying the intellectual property assets, like all the trademark, copyrights, and the patents. Third strategy from the perspective of M&A should be, according to me, the IP creation and documentation. You have to establish the procedures where you clearly document how of your IP. Like after the America's Invents Act was introduced in the US, now the patent application in US is first to file. So IP creation and documentation becomes very important, that you have to, as soon as you identify, you have to document in terms of filing in different jurisdiction, filing in whatever jurisdiction you want to file your IP in. Third, I think is enforcement and defense. You have your IP assets in place, you have your applications in place, you have your patents or trademark or copyright application, but how do you enforce them? How do you defend it to safeguard your IP, to safeguard the efforts and the time that you have already put into apply for these applications for your IP. So enforcement and defense becomes very, very super important. And of course, now you're developing your IP. Why are you doing that? That's the question sometimes I ask by the company executives. Because of commercialization and monetization. So next important strategy comes is you have your IP. What do you do with it? You commercialize it, monetize it. How do you monetize it? You sell assets or you license out your technology to different companies, which will definitely bring more revenue to your company. Again, another good strategy, I think, should be monitoring and maintenance of your IP. You don't want a situation that if there is an M&A deal going on and the buyer comes back to you and say, by the way, your IP has already expired. So your value or your negotiation straight away goes down, in terms of if you are being a seller. So having this monitoring and maintenance of IP is very super important strategy for any M&A deal. Then training, of course, training and educating your executives, educating the people who are responsible to make these deals, the CEOs, CFOs, or maybe even the board of directors, telling them what's the importance of our IP assets, how we are commercializing it, and why is my company's valuation is so high because of this IP I hold. The next, last, according to me, is the global consideration for your IP strategies. Now, because we have to tailor our strategies so that we can fit in different legal frameworks. Although all the major jurisdictions of the world, the US, United States, EU, Japan, Germany, Britain, they are all in fact, I would say most of the countries who are members of WIPO are bringing their legal framework at a common platform, at a common level. Still, however, the legal enforcement is a little bit different in every country. So I would say, and last but not the least, you should have global consideration when you're setting up your IP strategy. You have to think about different legal frameworks of the world. Now, advantages, these were the legal, there are some challenges also whenever you're setting up your IP strategies. Challenges are something you have to or you should overcome. Some of the challenges is, of course, nowadays rapid technological advancement. So the technology changes like in a snap of your finger, it changes overnight. So the innovation becomes, your innovation which you've already done becomes so obsolete, or it's very difficult for long-lasting effect for your previous innovations. So that is one of the challenges that you face. Then of course, globalization and jurisdiction, the problem as per the challenges of different legal frameworks, as I just said before. And there's an enforcement and piracy challenges as well, that you have to make sure, of course, if you are a bigger company, you are present in different jurisdictions, so you have to make sure that your enforcement and piracy is on top of the line, because you don't know who is taking advantage or who is pirating or who is introducing, using your technology and infringing your rights in different legal frameworks. Then one of the most important challenges, according to me, in your IP strategy is your trade secret protection. Because a lot of companies, they don't want to file, or they don't want to make their technology bring it to the public. So the trade secret protection is very important, from cyber attacks or maybe leakage, corporate espionage. These kind of things you have to be very, very careful. And as related to enforcement and piracy, there's issues of counterfeiting and brand protection, which comes in form of in the realm of trademark, which you have to make sure that there's no counterfeiting and brand protection. You're enforcing your brands, which has been established for so many years of hard work and so many years of marketing, or so many years of putting in money into the market. Then there's a major issue challenges nowadays is patent trolls and litigation from the non-practicing entities they especially target the startups. One of the most difficult challenges which I think is the evolving landscape of legal landscape around the world. So as I previously said, you are dealing with different legal systems of the world. So it has sometimes become very hard to keep update of all the legal challenge or all the legal developments in different legal jurisdictions. There are benefits as well. Of course, benefits are when you are dealing, when you're doing any M&A, as high your protection is, as high your value can be. As a seller, you can always put a higher price to your company or to your assets if you have a robust IP system. Then, of course, revenue generation, risk mitigation. Then you're also attracting investments to your company. If you are a listed company, the shareholders or the people would want to buy more shares of your company if you have a robust IP system. You have a strong technology and you are maintaining it as well. So your value in the market goes very high. I can keep on going for definitely for IP, but I know we are in short of time. But in short, in conclusion, I just want to say that having an IP-centric approach in your companies will give you a lot more mileage when you are negotiating any merger or any acquisition for your company. I'll be open to any question after the session, and thank you very much for this opportunity, Professor Wang. Really appreciate it.
Thank you very much for Mr. Kaushik's enlightenment.